Sam Seder, Emma Vigeland on the Majority Report. It is a real pleasure to welcome back to the program Ian Millhiser, senior correspondent at Vox, to give us a preview of the highlights, lowlights of the next Supreme Court term. Ian, welcome back. Always great to have you.
It's good to be here. I mean, unfortunately, it's my mournful and highly regrettable duty to inform you that the Supreme Court is back in session.
Yes.
Oh boy.
It has really been the past couple of years have really been, every time we talk, has been sort of upsetting and depressing. Much of this Supreme Court, at least now, in terms of we look forward, is going to be taken up by dealing with perhaps the only other more crazy court in the country than the Supreme Court. I want to get to that in a moment, but let's get to the one thing that you and I have been having conversations about, I feel like for 5 or 6 years now, and that is the biggest threat to the Chevron Doctrine, at least this year, that are going to be taking place this year. And it comes in the form of Loper Bright, is it Entertainment or Enterprises, and Raimondo. Fairly, what seems like on its face, a fairly banal case, but could have massive implications. Tell us about that one.
Sure. So the backstory here is that the Supreme Court has been engaged in a fairly long process of essentially seizing power from the executive branch of government and giving it to itself. So there are a lot of statutes passed by Congress that says that various executive branch agencies, the EPA, the Department of Labor, the Department of Education, what have you, have various authority to do all kinds of things. The most recent example of this was in the student loan case. Congress passed a law called the HEROES Act, which says that the Department of Education has very broad power to modify or cancel student loans during a national emergency. And the Supreme Court recently said, no, he doesn't actually have that power, because we now have the authority to overrule the executive branch. What the court has relied on in its most recent past decisions overruling the executive branch is something called the Major Questions Doctrine, which, as the name implies, it suggests that when the executive branch does something really consequential, when a federal agency does something really big, like forgive a lot of student loans, then the courts can step in and they can veto whatever it is that this agency has done. What remains of the Chevron Doctrine.
All right, wait, can we just stop at the Major Questions Doctrine for a moment, just to show the absurdity of this? This is something that no Supreme Court justice had uttered those words, I think, prior to the 21st century, right? I mean, it was just something that vaguely was sort of thrown offhand. I think it was it by Scalia at one point, or like 15 years ago? And we don't know what major means, right? There's no way, nobody can define major. It's one of those things the court has, like, we know it when we see it.
Yeah. So the history here is in I believe the year 2000, the Supreme Court struck down the FDA's attempt to assert control over tobacco. And it's a very long opinion. So it's called FDA v. Brown and Williamson. The court gives many reasons why it concludes that Congress did not intend the FDA to be able to regulate tobacco. Many reasons. It's a pretty convincing opinion. And one of the many reasons it gives is, after listing all kinds of evidence that Congress didn't intend the FDA to regulate tobacco, it then includes this one brief section that's maybe 4 or 5 paragraphs going on. It says, and one other thing that gives us pause here is tobacco is kind of a big deal. There's been a lot of political contention around tobacco. And we would think that if Congress wanted to give the FDA this kind of power, they would provide a clearer statute giving them with that power. So that was one of many reasons that the court cited in a very lengthy opinion, laying out all the reasons why they thought in the year 2000 that the FDA did not have the authority to regulate tobacco. Flash forward to the Obama years, and the Supreme Court started hinting that it wanted to expand that and say that if a federal agency does something too big, we might strike it down. But it was mostly just hinting that this could be something that could be coming. This doctrine then laid dormant for the entire Trump administration. So the whole time a Republican was in the White House, they didn't even mention that there might be limits on the executive branch.
Amazing that there were no major questions during the Trump years.
Yeah, I mean, and it's not like Trump didn't do anything big with his executive power. I mean, there was a freaking Muslim ban during the Trump administration.
But is that major?
Yeah, well, according to the Supreme Court, no, because they didn't bring up the major questions doctrine.
They know it when they see it.
So major essentially is dictated by the fact of how major is something that you're going to build that might threaten industry as opposed to breaking something down, because that's what the right does effectively, right? They're fine with taking major blows to the way that our federal agencies or operate. But if the federal agency tries to do something actively, proactively, that's when it's major, it seems.
Yeah. So the language that the Supreme Court has used is that when something has vast economic or political, that's the phrase that is used, economic or political consequences, then they're more likely to step in and impose the major questions doctrine. That word political is really significant, because what it essentially means is if the Republican Party whines enough about something, this has huge political implications. Look at all the controversy that it has inspired, and therefore we have the right to veto it. And that's what they did in the student loans case. That's what they did in a case striking down something called the Clean Power Plan, which is an Obama era plan to fight climate change that they recently struck down. And so the major questions doctrine, the way that it really functions is it's just if the Republican Party gets really upset about something, then the courts can step in and strike it down.
So that has been what they've used to sort of around the edges of the Chevron Doctrine. Right. But tell us what the Chevron Doctrine is and how it's implicated in this case coming up. Yeah.
So Chevron is a case from the mid-'80s, which said that when it's unclear if an agency has the power to do something that it wants to do, when the actual statute giving it the power to do something is ambiguous, then courts should generally defer to the agency's interpretation of that statute. And the reason why is twofold. One is that the agency knows more about the subject matters it regulates than the courts do, so it's more likely to get questions right when it's unclear what the law says. But the other reason why is that an agency is responsible to a democratically elected president. A court is not. And so it's more democratically legitimate to say, hey, let the agency what it's going to do. And if the people don't like it, they can replace the president in the new election. They can't replace the justices in the new election. So Chevron.
So in other words, an example of that would be Congress has said to the EPA, we passed the Clean Air Act. If you find pollutants in there that are bad for human beings, to keeping them alive, you have the authority to take that out. You have the authority to regulate that. And at one point, the EPA finds that hey, mercury is bad for human beings in this amount. We're going to say no more mercury can be burned into the air or dumped into the sea or whatever it is. And even though Congress never said mercury, right, they just said something vague. And then the court under Chevron would defer to the EPA. They know what they're doing. And if the American public has such a problem with so little mercury in the air, they can vote out the president at that time.
That's right. And again, the Chevron Doctrine doesn't say agencies can do whatever the hell they want. What it says is that if the statute is genuinely unclear, so if we're imagining a hypothetical statute that said the EPA shall have the power to ban pollution that releases harmful substances, and it doesn't define the term harmful substances, then under Chevron, if the EPA determines that mercury is a harmful substance, then courts should generally defer to the EPA's determination there. Chevron, if the statute said Congress can, or the EPA can ban harmful substances except for mercury. If you had a statute that says something like that, that is an unambiguous statute. And so the EPA doesn't have the power to ignore what Congress has said. But when the statute is genuinely ambiguous, Chevron says that we want the agency to make the determination because it has the expertise and the democratic legitimacy to make that decision, and not a bunch of unelected judges.
Fair enough. Okay. And so, Raimondo, why does this case, this case is one where the Chevron doctrine could be basically taken on dead aim. They're taking dead aim at the Chevron doctrine.
Yeah. So this case asks the Supreme Court to overrule Chevron, which would mean that all these, basically every regulatory decision made by a federal agency, the agency would no longer have the last word on whether that regulation stands. The judiciary would have the last word on whether that regulation stands. And again, under its major questions decision, the court has already said that it has basically an unlimited veto power over important regulations. So what this Loper Bright decision deals with is essentially whether the courts are going to micromanage every other thing that federal agencies are doing. And first of all, I don't know why the courts would want that power. The specific issue in the Loper Bright decision is that there is a regulation which says, first of all, that certain fishing boats have to have a federal monitor on board just to see what they're up to. And second of all, that monitor has to be paid for by the owner of the boat. And the owner of a boat is challenging that, saying that, no, they don't want to pay for this monitor. This is a tiny issue. No one really cares except for boat owners.
Well, Ian, do you own a boat? That's the situation here, right? Is they're representing when they can pick and choose in the situation, and they have the power to do so. For the most things, I would imagine they'll let things slide, except when they have some sort of industry group or, Harlan Crow calls up and it's about a real estate regulation, and that's when they invoke it. That's why they want the power to pick and choose, because then they get to choose.
Yeah, that's the danger there, is that the court's just going to start imposing its own policy preferences and the Republican Party's policy preferences, because 6 of the justices are Republicans, on pretty much any regulation out there. The reason why I describe this one regulation in this case is because it's so low stakes. If you want to do the economic analysis here, if the fishing company has to pay for the person on the boat, that doesn't actually cost that much money. They're just going to spread that around to their consumers, and you'll pay maybe a few pennies more for a piece of cod. Alternatively, if the government has to pay for this person to be on the boat, then you'll pay maybe a fraction of a cent more in taxes in order to cover the cost of the government paying. So the stakes here are virtually non-existent. It just doesn't matter that much, who pays for this observer. But in the aggregate, if the courts are suddenly second guessing every time the federal government makes a decision about anything, how much emissions can be reduced by nitrogen treating plants, what are the proper procedures for determining if someone is entitled to black lung benefits? What should be the rules governing safety rails at a particular factory? All of these tiny decisions that the government has to make that impact some people, but that don't have huge stakes. Who do you want deciding who decides what the safety rails look like at a factory? Do you want OSHA, an agency that actually knows a lot about safety rails at factories, to make that decision? Or do you want Neil Gorsuch to make that decision? That's what's at stake here.
It also seems to me there are two things that occur to me. One, that for the most implications, Chevron has been essentially dismantled. I mean, for the big questions, like we've seen it in terms of like student loan, when you're talking, and we saw it with the Clean Water Act. And I think we're going to see it for other things come forward. Major questions doctrine is basically like this sort of like get out of jail free for people who are scofflaws or who and it just trumps everything. It's like a wild card that they can play at any time. The implications of this seem to me to be you would create just a tremendous amount of chaos because every single person, I have a pest control business. The FDA says I can't use this thing, spray it around kids and animals. Well, I'm not doing that. The Chevron Doctrine's gone or whatnot. And we would just get a ton of these things and things would go into chaos. But in terms of the major questions, that game seems to be over, more or less.
Yeah, no, that's exactly right. Yeah, the major questions doctrine has essentially established that when the Republican Party feels very, very strongly about something that a government agency has done, then the Supreme Court can step in and veto this thing that the Republican Party doesn't like. And like, there's a lot of big important things there. I mean, lots of your listeners probably are not getting their student loans canceled, are are out a whole lot of money because of the Supreme Court's major questions doctrine. They canceled out Obama's biggest plan to fight climate change, although actually the Clean Power Plan wouldn't have done much anyway. But at the time, we thought it was going to do a lot. The major questions doctrine, when there's something that the Republican Party really hates, the Supreme Court already has the power to veto it. The question here is everything else. And everything else is a big category. The Code of Federal Regulations is about 200 volumes long. There's just a lot of stuff in there. And again, the question is like, when you're dealing with something like, how much wastewater can be released by, or how much waste can be released by a nitrogen treatment plant? I don't know the answer to that. I'm a lawyer. Nothing I learned in law school taught me anything about, waste released by nitrogen treatment plants. Nothing that Neil Gorsuch learned in law school taught him anything about that either. He has no clue what the proper answer to that is. Who does know the answer to that question? The EPA, because it's their job to know the answer to that question. And so, just think about 200 volumes worth of things that like well thought out experts have decided here's the best way to do things. And now we're just going to pick a bunch of rando lawyers with black robes and say they get to decide those instead.
All right, I want to move on, but I just want to note one thing about the Chevron Doctrine. My understanding is that case that forged the Chevron Doctrine, Gorsuch's mom was the head of the EPA at that time.
I think she'd had to resign by the time the case actually reached the Supreme Court. But yeah, I mean, the important thing to understand about not just Chevron, but like this issue of whether a court should defer to the executive branch is the courts moved in the direction of deference, of saying that we should, let the executive do what it needs to do during the Reagan administration. And Republicans were really hot on Chevron at the time because Reagan was promoting a deregulatory agenda. They wanted Ronald Reagan to be deferred to. When did they start talking about rolling in the Chevron Doctrine? Well, that Brown and Williamson case, the tobacco case I told you about, that was something Bill Clinton did. And then they did a little bit of rolling back under Barack Obama. They then didn't mention any of this at all under Donald Trump. And then all of a sudden they create this huge, expansive major questions doctrine, which has only been used to strike down regulations pushed by the Biden administration. So look, I believe in democracy.
Amazing coincidences.
Amazing coincidence. I believe in democracy. I believe that Ronald Reagan won 2 elections fair and square. And if the American people wanted Ronald Reagan's deregulatory agenda, then he should get to implement it. But we've had quite a number of elections since then. Ronald Reagan's approach has fallen out of favor with the American public, and the Supreme Court should honor that as well.
Fair enough. I agree. All right, let's go to the other bulk of the cases as of now anyways that the court's going to hear. And those are sort of like, they're coming out of the Fifth Circuit. Just tell us a little bit about the Fifth Circuit, because this sounds like the strategy was you get a circuit that's going to create all of these, that's basically going to be a pipeline to the Supreme Court, because it's going to find, it's going to be the sort of, I don't know, the USS Enterprise, the Star Trek version here. We're going to cross boundaries that we've never crossed before to see where we are at the Supreme Court.
Yeah, I mean, I think it's, I would make more of a Star Wars joke than a Star Trek joke if we're talking about the Fifth Circuit, because there's no greater hive of scum and villainy in the federal judiciary.
Okay, fair.
Yeah, the Fifth Circuit is, and there's just no charitable way to put it. It is a bench dominated by cranks. Donald Trump appointed 6 people to the Fifth Circuit. It had long been a particularly extreme court, and now, I mean, the stuff coming out of the court right now doesn't even resemble law. So, like,
and just to be clear, just so that people know, because I'm not sure people are familiar with this, there are 13 circuits around the country. This one represents Louisiana, Mississippi, and Texas for the most part, right? I mean, there may be, I'm not sure, that's just broadly speaking. And so if you sit on that court, you're basically nominated with the blessing of the senators from those states. So you get a sense of like who the filter is, just to be clear. And like you say, 6 appointed by Trump, 12 by Republicans out of the 18.
Yeah. So the history of how the Fifth Circuit got to be so crazy is that there is this thing called the blue slip, which used to mean that any judge nominated from, or at least during the Obama administration, when Senator Leahy took it a little too seriously, basically home state senators had an unlimited power to veto any judicial nominee to a federal judgeship in their state. And so, we're talking about Texas here. That means that Ted Cruz had an unlimited veto power over anyone appointed to one of the Fifth Circuit seats in Texas. The Mississippi senators had an unlimited veto power. And so, like, Obama, I mean, I think he appointed 1 or 2 judges to the Fifth Circuit, but like there was basically a blockade. And Trump came into office with a bunch of Fifth Circuit vacancies that should have been filled by Obama. And then Trump filled all of those, plus all the vacancies that opened up while he was president. And so that's why you had this court that was already fairly extreme that just became loopy. And so to give you a sense of the loopy stuff they have done. So there's a case being argued tomorrow, actually, where the Fifth Circuit declared the entire Consumer Financial Protection Bureau unconstitutional. Now, if this entire CFPB is unconstitutional, that means we have basically no consumer banking regulations. It also means, like, there's a bunch of laws that banks have to comply with, and the banks need someone to write rules telling them, like, in specific detail how to comply with those rules. Like, if you've ever signed a mortgage before, all those documents that you have to sign that use all that thick boilerplate language, many of those documents are written by the CFPB. And if the CFPB doesn't exist, the banks don't know how to comply with the disclosure rules and various laws that they have to comply with, which means that they cannot issue mortgages. And if they cannot issue mortgages, then we potentially lose 17% of the US economy overnight, and that's a Great Depression level event. So you have the Fifth Circuit handing down this decision that makes no sense. I mean, I can go into why they said that the entire federal agency is unconstitutional, but it makes no sense. That would have sweeping catastrophic consequences for the world economy. Would do more damage to the United States than like anything since Pearl Harbor. This is the kind of reasoning that we've got coming out of the Fifth Circuit.
And it's based on a very sort of bizarre reading of Congress's ability to appropriate appropriate funds and to, I guess, to sort of, decide how. It's specifically written in there. I don't know how they interpreted it that way. I mean, the language in the Constitution is, You can't spend money from the Treasury unless Congress says you can. And Congress says you can here in this situation. That's it. But okay, tell us some more of these cases, because there's going to be a series of these things. At one point, does the Supreme Court say, hey, Fifth Circuit, take it easy?
Yeah.
Like, I mean, you're taking up too much time.
To be honest, I am fairly optimistic that the Supreme Court's going to lay some smackdown on the Fifth Circuit. You know, they have laid a little bit of smackdown already in previous terms on the Fifth Circuit. I mean, look, I don't like Amy Coney Barrett. I don't think she's a particularly good judge. I don't appreciate the fact that she voted to overrule Roe v. Wade. I don't appreciate that she supports the major questions doctrine. I don't like a lot of things that she does. She's not a terrorist. Like, she doesn't actively want to destroy the United States or like set a nuclear bomb off in the middle of our economy. And that's what would happen if the Fifth Circuit was affirmed in the CFPB case. So like, I'm fairly confident the Fifth Circuit is going to get a big old fist brought down upon them there.
Are there other cases? I know you just got a couple minutes here. Are there other cases that you think that the Fifth Circuit is pushing that is going to be problematic?
Well, so there's one case that I do want to discuss. This is a case called U.S. v. Rahimi. The law here, which the Fifth Circuit struck down, is a law saying that if a court has determined, so if you have a restraining order against you, because a court has determined that you are a violent threat either to your romantic partner or to your romantic partner's child, then you may not own a gun. So, like, to be clear who we're talking about, there's been a court proceeding. The court has determined if this individual has a gun, they may use it to try to kill their wife, to kill their girlfriend, or to kill their girlfriend's child. This is the universe of people we're talking about here. The Fifth Circuit struck that law down. The Fifth Circuit said that wife beaters have a constitutional right to own a gun.
And this is because of the New York State case, right?
Yep.
Where the Supreme Court said our gun laws have to look like they did in 1776.
Exactly. And like that brings me to the worst part of this Rahimi case. The worst part of the Fifth Circuit's decision in Rahimi is I think they got it right. I think that, like, if you accept that previous Supreme Court decision, Bruin, which said that you have to look at what the gun laws looked like at the founding to figure out which gun laws we can have now. Well, it was legal to beat your spouse in all 50 states until 1871. It wasn't until 1871 that the Alabama Supreme Court of all states ruled that it was you could indict someone for beating their spouse. So, and then there were 49 states where, it was still legal. So, if you accept what the Supreme Court said in Bruin, that we have to tie our gun laws to what the gun laws looked like in 1789, then I guess you have a constitutional right to own a gun, even if you are a violent threat to your own spouse.
And just to be clear, the law says that there has to be a hearing to adjudicate this. So their law is not like making a sweeping assessment. It's saying that we're going to leave it up to the courts to be able to like look at this person and make this determination. So the long and short of it is that this case is going to force the Supreme Court to reevaluate what they did in Bruin, right? And it's got to be embarrassing for them. It seems.
I would hope so. Again, like, operating on the theory that Brett and Amy are not terrorists, like, I think any normal person hears this case, the holding of this case that I described, that people who a court has determined are a physical danger to their spouse, to the romantic partner, or to the romantic partner's child, has the right to own a gun. Any normal person hears this. No, that's wrong. That cannot possibly be correct. What I think is likely to happen is that Kavanaugh wrote a concurring opinion in Bruin where he said there are some categorical carve-outs to the Fifth Amendment, to the Second Amendment. So, like, you can't own dangerous and unusual weapons. You can't bring guns into sensitive places. I think the court will probably create a dangerous persons carve-out or something like that. So if you've been determined to be a dangerous person by a court, then you can be disarmed. But again, like, it's a pretty spooky case because, like, most of the time when I rag on the Fifth Circuit, it's because I think that they did something completely lawless. Here, I think they followed the law. The problem is that Bruin is insane.
Yeah, and I think it's going to make it really clear. I mean, the more carve-outs they have to this sort of like magical, we go back to what they were thinking in 1789, except for in these instances where we realize that's not workable, is just ridiculous.
Yeah.
Ian, I know you got to run. I hope we can do this again because as the cases are heard, really appreciate your insight to these things. Thank you so much.
Thanks so much for having me, Sam.
Thanks, Ian.